Hey guys, welcome back. I'm Brad Woodall with probateresource.com. Today I am here with April Jackson from Tennessee, and she's back with us again, and we're covering some various topics. And today I want to talk about heirship affidavits. Not all states have heirship affidavits, and I think they're, personally, having done this business for many, many years, I think heirship affidavits are actually a good thing because a lot of families only have a house or a car or whatever, and to have to go through the whole probate process just to sell the one thing is kind of a pain in the butt. So, April, why don't you kind of touch on when someone would use an heirship affidavit versus when they wouldn't in Tennessee? Where does that come into play?
Yeah, so the affidavit of heirship is specific to real estate in Tennessee. We also have an affidavit of inheritance for vehicles.
Okay.
But when we're talking about an affidavit of heirship, that is really, we are creating a chain of title from somebody who has died to someone who is living and who is inheriting that property. And so best practice in Tennessee is to make sure that the person that's completing the affidavit is not someone who is inheriting. So it's not the new owner of the property.
Right.
But, it could be a cousin of another family member. It could be a neighbor. It could be somebody who was familiar with the deceased person through a faith community. There are a lot of other people that we may, try to reach out to. And really what that person needs to have personal knowledge of is their belief that the person owns property, and that the individuals named in the affidavit are the people who inherited it from that individual, either through a will or through intestate succession, which I know, we kind of have to look at what is the person signing going to actually know. So a lot of times you're kind of piecing that together in terms of, well, I know that Miss Susie lived at 123 Main Street, and she told me she owned her house. And I know that Miss Susie only had 2 children based on what she told me. And those children were, Jane and Jack. And so that affidavit would be, 123 Main Street belonged to Miss Susie, and Jane and Jack were her children, and so now it belongs to them. And so really we are going to use an affidavit of heirship anytime that someone has died without a joint owner.
Okay.
So if you own a property with a survivorship, and in Tennessee, it does have to be specified in the deed.
Yes.
You can't say joint tenants. In Tennessee, it has to say joint tenants with right of survivorship, or be owned together by spouses. So if you have that right of survivorship or that spousal deed, then the surviving spouse gets it, or the surviving owner gets it. They don't have to go through probate. They own the property now. But what you will want to do is when that survivor dies, then you will want to do your affidavit of heirship. And sometimes we do these in our office as part of probate or non-probate assets. And sometimes we say, hey, your title company is going to take care of this. If you've already got a title company, you're selling the property, just let them do it. But really kind of the difference between that is, are you selling it or are you holding on to it for a while? In our office anyway. So that's kind of the, you need to find somebody who, has an arm's length relationship with the family and the people who are inheriting. And then what we will do, or the title company will do, is we will record that affidavit of heirship. And once we record that, that is, anything that you put in the Register of Deeds office is public notice to the world that this person is now owns the property. So even though the affidavit of heirship itself doesn't necessarily, basically what it does is it creates a rebuttable presumption that these people now own this property. And if somebody wanted to challenge that, they have 20 years to do it.
20 years? Oh.
Yeah.
That's a long time.
It is a long time, but I've never seen an affidavit of heirship be challenged.
Sure.
I don't think it happens very often, but it's a possibility. And that's something that the title company will take into consideration when you sell the property.
Well, and title companies, first of all, title companies rule the world when it comes to real estate because they are the holders of title insurance, and most mortgage companies in the world will not allow it. They will not allow a mortgage on a property unless there's a title policy and they have clear title, right? Which rightfully so. I just had my second title claim I've ever had in my history of doing this. I had one a few years ago, and title insurance is a good thing. Also, you mentioned, going through a title company. If you're doing a sale, this is just like a side piece of advice here, just from my own experience doing this for years. But A, always buy title insurance. You don't have to, but I recommend it. And then B, if you're doing a real estate sale, make sure that you have a real estate attorney and or a title company facilitating that transaction for you. I've seen so many cases of, for example, where we were supposed to close on a property this week, and the lady and the neighbor had done a quit claim deed over a portion of a sliver of the driveway that was the driveway was encroaching on the neighbor, and they kind of fixed that, right? But they did it themselves. They went online, found a DIY quit claim deed, and tried to fix it themselves. And then now my attorney has to fix it because they didn't do it right. And in order to close and get an insurable title, we've got to do a corrective deed. So we've had to track down the neighbor and get a hold of the neighbor and find her and have her sign this and have it notarized and witnessed and all the things. And it's like, just make sure you're doing this through either depending on what state. In Tennessee, you guys have title companies and attorneys. Actually, one of the attorney outfits that I close with here in Atlanta sometimes has an office in Nashville, because I've closed a deal in Nashville at their office on property here in Georgia before. Nice. So anyways, that's my piece of advice there on that. But I mean, thanks for clarifying the heirship affidavits. I think it's a great thing because it saves a lot of time.
Yeah, especially because I know some states have a transfer on death deed, so you can just say, I want this to go to my kid, and you can put that in writing. But Tennessee doesn't have that, so the affidavit of heirship or having joint title is really the only way to clear up that title when somebody has died and not purchased, when it's not a buyer-seller transaction.
Right. Yeah, I live in the state of Georgia. We just got transfer on death titles approved this year in the Georgia Assembly, like just this year, finally.
Oh,
so it just happened. So yes. All right, great. Awesome. Well, guys, if you heard about Heirship Affidavit or whatever, if you need some help filling out an Heirship Affidavit, I believe April has a resource available for that. So if you will connect to her website below, and then she can connect you with that resource in terms of if you need any tips. Obviously, we always suggest in any case of any real estate or probate situation, inheritance, you should consult an attorney to make sure that you're doing this right. And sometimes that's going to cost you money. Sometimes it doesn't. Most of the time it's going to cost you money, but it's worth it because you want to make sure that you're doing things correctly.
Pay now.
What's that?
Pay now or pay later.
Right. You're either going to pay now or pay later, and it usually costs more money later. So just FYI. Awesome, guys. Well, hey, guys, again, I'm Brad from probateresource.com. I hope this was helpful. Go check out probateresource.com/Tennessee. We've got a whole bunch of other videos around probate and estate stuff in Tennessee. So thanks for joining in. Stay tuned for the next video.